Hello everyone, a very good evening to all of you. Welcome to the Officer Adda 24/7, the special session of the BRBL subject in the English medium language. So myself, Advocate Nikita, so I'm presenting important questions and the case studies question of the BRBL subject. Let's start with the session today. I have just taken a one paragraph based question. Okay, so paragraph based question is totally, I can say that is totally depend upon the concept. So if your concept is clear now, you can easily understand the questions and easily do the question. So let's start with the session. So C class. This paragraph based question is based on the contract of indemnity and contract of guarantee. So first of all, we have to discuss this from where this concept has been arisen. So class, Indian Contract Act, okay, that is divided into two parts: general principle of contract and the special principle of contract. Okay, general principle of contract section 1 to 75 and special principle of contract section 124 to 238 talks about the special principle of contract. Okay, indemnity and guarantee, that is a part of the special principle of contract. That is indemnity, guarantee, bailment, pledge, agency. These are the five concepts of special principle of contract. Okay, and in general principle of contract, offer plus acceptance is equal to promise. Promise plus promise, in legal term it's called agreement. In agreement, when law will be enforced, that is equal to contract. So that is a formula of contract. Is that okay? So contract of indemnity, section 124 talks about the contract of indemnity and section 126 talks about the contract of guarantee. So that's a brief introduction that I have just introduced you before starting the paragraph. Okay, so now you have to first of all understand what is indemnity and guarantee, because C class, in your exam now this will be not given. In your exam, this contract of indemnity and guarantee or whatever the concept before paragraph will be not given. I have just put this particular word so that you can easily understand that what we are going to study in this paragraph. Okay, if we talk about the contract of indemnity class, so indemnity is nothing but all the insurance examples are the contract of indemnity. So what is insurance? So insurance in which two parties are there, XY. One party's loss is there, another party loss, profit is there. Loss and profit, that's a contract of indemnity. Suppose if anyone taken the this one health insurance, if anyone taken the health insurance, that is, or marine insurance, house insurance. So insurance means the company is protecting you and you are giving the premium. That is called contract of indemnity. Okay, now let's understand in that this particular this one. Except life insurance, the life insurance not covered under the contract of indemnity. Okay, this X person is called indemnified or indemnity holder and Y is called indemnifier. And contract of guarantee, there are three parties: principal, debtor, creditor and the surety. So there are three parties in the contract of guarantee. Is that okay? Now let's start with the session. See, the term indemnity literally means the security against the loss. So that is the definition of the term indemnity. Okay, in a contract of indemnity, one party is indemnifier, the person who promises to compensate the other party, that is indemnified, the against whose the loss suffered by other. So there are two parties. Okay, indemnifier, you can also say it promiser, and indemnified, that is called promisee, and this is also called indemnity holder. The English law defined contract of indemnity as a promise to save a person harmless from the consequence of an act. What is this? Promise to save a person from harmless from the consequence of an act. Suppose if you taken the health insurance, if anything will happen to you, the company will pay. That's the example of health insurance. Okay, so all the insurance are the example of contract of indemnity. The company will be called as an indemnifier and the person who is taking the insurance is called promisee and indemnity holder. Is that okay? That is also called indemnified. Does it include within its ambit losses caused not merely by human agency but also those caused by accident or by fire or by other natural calamity. Is that okay? As per section 124 of Indian contract, the contract of indemnity is that contract by which one party promises to save the other from the loss caused to him by the conduct of the promiser himself or by the conduct of any other person. So that is a simple definition that is given in section 124 of the Indian Contract Act. Is that okay, class? Cool? Done? So this is the exact definition of contract of indemnity. Done? Now the next one. The definition provided by the Indian contract confines itself to the losses occasioned due to the act of promisor or due to the act of another person. It means in Indian Contract Act, anything which is done by the promisor or due to the act of any other person, in that way the indemnity will apply. So under the contract of indemnity, the liability of the promisor arises from the loss caused to the promisee by the conduct of promisor himself as per the indemnity contract. Every contract of insurance, this line is very important. Every contract of insurance other than life insurance is a contract of indemnity. So this definition is restricted cases where loss has been caused by some human agency. Section 124 deal with a one particular kind of indemnity which arises from a promises made by the indemnifier to save the indemnified from the loss caused to him by the conduct of indemnifier himself or by the conduct of the other person, but does not deal the classes. This is very important. See what is given, but does not deal with those classes of cases where indemnity arises from the loss caused by the event or accident which do not depend upon the conduct of indemnifier or any other person. Is that okay? This is very much important. This particular line is important because so many candidates also take mark that if anything happened by the accident or whatever, then also we can claim. No, we cannot claim. Okay, so it does not deal with the class or classes of cases where indemnity arises from the loss caused by the event or accident which do not depend upon the conduct of indemnifier or any other person. Okay, so in the contract of indemnity, two parties are there: indemnifier, indemnified. Okay, indemnified is also indemnity holder. Now it's a contract of guarantee. So contract of guarantee class involve three parties: creditor, principal debtor, surety. And indemnity is for reimbursement or a loss, while guarantee is for security of a creditor. In a contract of guarantee, the liability of the indemnifier is primarily arises when the contingent event occur. In the case of contract of guarantee, the liability of the surety is secondary, arises when the principal debtor default. Exactly, because in contract of guarantee, what's the basic thing? If the principal debtor will suffer loss, then only the surety will come into picture. So this is the basic thing about contract of guarantee. Okay. The indemnifier, after performing his part of the promise, has no right against the third party. He can sue third party only if there is an assignment in his favor. Whereas in the contract of guarantee, the surety step into the shoe of creditor on the discharge of liability and may sue the principal debtor. That is important one. Is that okay? Now let's start with the question and answer of this one. A hires B to kill C. AB enter into the indemnity agreement where B will be reimbursed if B is hurt and injured in the process of killing C. B gets hurt when he tried to kill C. Will B claim reimbursement? Just try to understand the concept, then give me the answer. The first option is no, as the contract between A and B is illegal. Second, no, as the contract between A and B is a valid contract of indemnity. C, no, as the contract between A and B is unenforceable. Or D, none of the above. So just please think particular question and then just give me the answer. This is very important part. Yes, class. Yes, class, what is the right answer? So class, many of you will think that this is, ma'am, absolutely the contract of indemnity. Right now, just think what exactly this want to say. A hire B to kill C. A, B enter into the indemnity agreement where B will be reimbursed if B is hurt and injured in the process of killing C. B gets hurt. Now, if the loss will be happen to the one person, what I'm saying, if the loss will happen to the one person, so the protection of loss will done by the other person. So can B claim reimbursement? The answer is yes, because the contract between A and B is a valid contract of indemnity. Don't think that about the subject matter of the contract. The only thing, the concept they are asking, that whether it is contract of indemnity or not, that's it. So yes, this is a contract of indemnity, valid contract of indemnity between A and B. So this is the right answer. Is that okay? Done, class. So this is the first question that is totally based on the paragraph. So this is just like the paragraph based question. So you have to do the questions. Okay. Next question. B promises to indemnify A promises to indemnify B to him. A promises B to indemnify him in the case his house is damaged by fire. B negligently light up the firecracker in his house and burn it down. Now B wants the claim of indemnity. Can B gets reimbursement? B gets reimbursement, class? No, as the B was negligent and caused damage to his house. No, as a AB cannot have a contract of indemnity for damage caused by fire. Yes, as A promised to indemnify B from any damage caused by fire to his house. Yes, it was a moral duty of A to indemnify B for the damage to his house. Just tell me the right answer. That is very good question. Yes, class. What is the right answer? So for this one, the right answer is yes, as A promised to indemnify B from any damage caused by the fire to his house. It is not, we have to see that whether it is negligent, accidentally. No, the fire is there, so that person have to fulfill the promise. So C is the right answer. Okay, cool. Next. A, B enter into the contract of indemnity. A promises B to indemnify B in the case of any damage to his car while he is in driving. B's servant crashes the car. Can B claim indemnity? A, yes, as the AB enter into the valid contract of indemnity. Yes, as the A is legally bound to pay. B, as per contract of indemnity. No, as B should have been careful while giving the car to his servant. No, as the car did not get damaged due to the conduct of B. So what is the right answer? Yes, class. Can B claim indemnity? So class, according to this question, the servant have done the work. So here B cannot claim the indemnity because the car did not get damaged due to the conduct of B. So D is the right answer. Okay, according to the paragraph. Now, X is a foreigner, promises to indemnify Y if his business in the UK suffer any loss. Y business get destroyed due to the floods in the city. Can Y claim indemnity? Okay, oh see class, this is the English as per English law. Na? In the contract of indemnity, the losses will be caused not merely by the human agency but also by the accident, fire, etc. or natural calamity that is happen in the English law. Okay. So the fourth question is X the foreigner promises to indemnify Y if the business in UK suffer any loss. Y business get destroyed due to the flood in the city. Can Y claim indemnity? Yes. The contract of indemnity also includes damages from natural calamity. No, as the contract of indemnity exclude damages from natural calamity. No, as this does not fall under the preview of contract of indemnity. Either B and C. What is the right answer for this question? That is very good question. So class at is already given in the English law. Okay, in the English law it is already given that yes, if it is caused due to the flood, that is a natural calamity. So yes, this is the contract of indemnity includes damages from the natural calamity also. Okay, A is the right answer. Next, A takes credit from B from starting a new business, and on in instant of B, A appoints C as a surety. Okay, A's business venture was immensely hit by the recession in the market. He fails to pay the due. B sues C for the money which he owes from A. Decide. The family member of A will have to pay in the case of any default. B will have to go to the court and claim the repayment of credit from A alone. C will have to pay as he is the surety of A. No one will be liable to repay the credit amount as there was no free consent for the appointment of surety. What is the right answer? So this is contract of indemnity, this one guarantee or not, because in contract of guarantee there are three parties. In contract of indemnity there are three parties, there are three contract in contract of guarantee. So class, in this one she as a surety. So if there is a loss, fail to pay his dues, so she will have to pay as he the surety of A. So that's why C is the right answer. So class, this is called the paragraph based question, and I hope so you people like the session. So this is your crash course. If you have not enrolled in the crash course, kindly enroll. By applying the coupon code Y391, you can get the maximum discount in this batch. Y391. You will get the live class, two-way interactive live class. Okay, you will also get the discount by applying this coupon code. You will get the ebooks, mock paper, etc. So apply this coupon code for the maximum discount. It's okay. Thank you so much for attending the session. And if you want to just take a Mahapack, you can just take the Mahapack also. Okay. Thank you, class.